Welcome to Design Domination, where you'll learn to become a better designer so you can dominate your competition. Hi everyone, thanks for tuning in. I'm Colleen Grotzer, and in this episode of Design Domination, I'm going to talk about estimates and contracts. Providing clear estimates and contracts sets expectations for everyone involved and covers your you-know-what. Stick around to find out when I use a contract, what I take into consideration when pricing work, and what I include to protect myself from scope creep or potential legal issues. Note, I'm not a lawyer, and what I'm going to talk about should not be taken or relied upon as legal advice. I've had a lot of experience in many client situations over the past 21 years, and I've worked with lawyers to refine my agreement terms. So I'm just sharing my own knowledge and experience. Some of it may or may not apply to your situation or your jurisdiction, so be sure to consult a lawyer. A formal contract isn't necessarily needed for every single project. Before working with a new client, though, I always have a formal contract in place, and that gets signed electronically. For new work for existing clients, I usually provide an estimate or a statement of work via email and then have them accept it by clicking an accept button on the estimate or responding to the email that they accept it. And that will include what's being done, so the scope of work, when it's due, the rate for the work, and what they're getting, which is the deliverables. Now, if I've only done print work for a particular client and they now want a website, that warrants a new and separate contract because the nature of that work has different terms, which I'll get into later. If any terms have changed since I last worked with a client, that's a good time to have clients sign a new contract. So I could have a document or page on my website with terms like a master service agreement, and I could reference that in an estimate or a statement of work instead if I wanted to. So that you can provide a more accurate estimate, there's many questions that I recommend you get answers to depending on the nature of the work. So in this episode, I won't include what to cover when consulting with the client over needs and goals, target audience, etc., as I'll cover that in another one. So the first is, what is the deadline? Faster means that you should charge more unless you're not that busy. You don't want to find out later that the job was a rush and that you should have charged more to account for that. Plus, you might need to now stay up later or work weekends to get it done on time. The second is there an existing brand style guide that needs to be followed? If so, that could only be a few pages or it could be 50. So consider the time that you need to spend reviewing it. Does the design need to look at all like any other materials? Like something in a series? If so, then you likely don't need to spend as much effort on design. Can the client provide a few pages in Word so that you can review the setup and the content? By setup, I mean, did they happen to use paragraph and character styles for formatting the text? Or are they like most clients who don't use any styles and you will need to manually apply them? In the former, and very rare case, it makes layout a breeze because you can import or map those styles into your page layout program. The latter will take a lot more time. Paragraph and character styles also make it easier to add text to a website because it retains the formatting. And now by content, I mean, are there graphs, charts, figures, sidebars, and hyperlinks to be addressed? And are there a lot of them? Or is the content mostly text? So let's say you want to lay out a catalog, and that's typically 200 some pages. Well, there's a lot of time to be accounted for to not only place the text, but the images as well. But you also may need to adjust or crop some of them. And will photos be provided by the client, or will you need to find them? And are we talking 10 photos or 100? You may or may not know that at this point, but account for the hours that you will spend searching for the right photos. Alternatively, though, they might need your help arranging for custom photography or illustration. Does the client need any proofreading or editorial assistance? That may be an additional service that you provide, or you may recommend a colleague who does that or have that colleague work as part of your team. Regardless, you want any editing or proofreading to have been done before you start working on the design or layout. Now, there are some considerations that are specific to design or layout work that is for print or digital purposes. So, how will the work be used or distributed? Do they need native files because maybe they have an in-house designer who can make subsequent edits down the road if needed? Will it be printed? Okay, then you need to provide a press quality PDF. Will it be distributed online? Okay, so then you provide a web quality PDF with the bookmarks panel set to open in Acrobat. If it's the latter case, does the PDF also need to be accessible per Section 508 or ADA guidelines? Few designers know how to do this, so you'd need to find someone to outsource that to. And will the work also need to be produced as an EPUB? Same there, you may need to outsource that part of the work. If it's for print, does the client need you to get print bids? Consider an hour or two, or maybe more, to consult with the printer if needed about any file setup, compiling the specs for the print bids, emailing printers, and answering any questions and reviewing proofs. Do any graphs need to be recreated to look better or restyled to be consistent with any brand guidelines? Do any of them need to be rekeyed because they're not legible? I once worked on a 400-some page book where I had to restyle about 200 graphs to use the same colors and fonts, type size, and line thickness. That was a lot of work. If it's a book design, do they need a cover design and inside layout? If the client has in-house design staff, they may design the cover in-house and have you do layout only. They might have you do the cover design only, or they might have you handle all of it. If you'll be doing the layout, you also want to find out if there will be an index. Depending on its complexity, you may be able to do that yourself with an InDesign plugin, if the client can provide a list of terms, or you may need to find a professional indexer for that. Other considerations are specific to website design and development. Will you be designing and/or developing? If developing, of course, it's best to see the design first so you know what you're dealing with, the complexity of the design, how many page templates need to be created, etc. Will this be work that you can accomplish with an existing theme, or will this need to be heavily customized work? Are any integrations or custom functionality needed? And can this be done easily with a plugin, or will you need to write custom code for it? Does the client need help figuring out what should go where on the website? If they have an existing website, do they need help figuring out if they should remove content and what should stay? Will you need to redirect a lot of links? If the client is looking to change a lot of the content on their site, you may need to redirect quite a few pages. And will you also need to address any performance or security issues if you're not creating an entirely new site? Now, scope of work. A scope of work is essential to establish the parameters around the work that you'll be doing. Otherwise, you could end up going down a very unprofitable rabbit hole. I think of the scope of work as a compilation of the information from all of your conversations with the client. I recommend always including the following items in the scope of work. The first is the details about the work. Specify the nature of the work, whether it's book design and layout, website design or development, etc., and then the details about it. Pretty much include the answers to the questions that I mentioned. The more specific that you can be, the better. I once had a client I did a book for, and they changed the size of the book just before it was about to go to the printer. I had listed the size in the scope of work, which just made it easier to say that there was going to be a charge for that. The second item is a number of designs. Regardless of how many designs you may provide, I suggest using the words up to X designs. So let's say it's up to 3 designs. If you create 2 awesome designs, you're not obligated to provide a third. Plus, if you said you'd provide 3 and didn't use the words up to, the client may ask to pay less because you didn't provide a third. Trust me, I've heard it all. Some clients, bad ones, are focused on quantity and not quality. This makes where you draw the line that much clearer. The third is revisions. Specify how many rounds of design refinements or revisions are included. Alternatively, this could be a set amount of time, say X number of hours. The caveat with number of rounds is the potential for the client to make tons of revisions at each draft. The caveat with time is that the client cannot readily tell where they are with that time as they can with drafts. Regardless of which way you choose to do it, I suggest using the words up to and of decreasing complexity. So if they get, let's say, up to 2 rounds of revisions of decreasing complexity, they shouldn't be rewriting and sending all new text on round 2. Believe me, I speak from experience. I once had a client I did a conference brochure for, fitting in and formatting an insane amount of content. On the second draft, they sent all new text, no changes were tracked, and I had no idea what had changed. I had to redo most of the work. I felt I couldn't technically charge for that because the number of drafts had not yet been exceeded, so I sucked it up. But then after turning it around for the client to review again, I expected an approval to send it to the printer. Instead, the client said, "Oh, we still have another round of revisions left, right? Okay, let me see what other changes we can make." I'm sure you can imagine just how furious I was, which led me to put this very line in all contracts since then. The fourth item is the amount and type of content. You can reference a file if they send you a Word document to review beforehand, or an approximate page count. I sometimes even list approximately how many graphics, photos, or sidebars there are. That way, if what the client ends up sending me exceeds that, or the content changes drastically, I can let them know that it's out of scope, meaning more work and it might cost more. Now, a note about referencing page count, whether it's for a publication or a website. In publishing, a standard page is considered to be 250 words, and web pages, of course, vary in length. So it's necessary to base what you consider a page on a constant measurement. Say, for example, that you price a book for one client who had 80 pages in Word, and you use that as a basis to estimate a similar book for another client down the road. The first client could have crammed in a lot more words per page in smaller type size and half-inch margins in their Word document, and the second client could have fewer words per page because they used 1-inch margins. Using the measurement of 250 words as a page, make sure that you're always comparing apples to apples to understand how many pages that you're dealing with before laying them out. And I emphasize before laying them out because your design choices, of course, will affect the laid out book and how many pages it contains. But hopefully you get the idea. It's about setting some parameters to provide more accurate estimates now and in the future. With rates, there's various rates to include in your estimates and contracts. There's flat rates, hourly, and a combination of the two, and minimum rates. Flat rates I recommend for most work, especially creative work, as opposed to charging by the hour, which personally I do only if it's for updating a brochure or content on a website, something minor. I also like flat rates for work where you have an idea of how long something will take and you're really fast and good at it. While you could charge hourly for that work, if it takes you less time to do it and the client can get it sooner, why should you be paid less, right? The value to the client hasn't changed, it's only increased. Plus, flat rates give the client a better idea of what to expect to pay. If you provide only an hourly rate, that doesn't help the client understand their actual costs unless they have an idea of how long it will take you. So you need to include that as well. But hourly rates put the emphasis on your time and not your expertise, so proceed with caution. By the way, if you don't know how long projects take you, I cannot stress enough how important that is. Even if you don't charge by the hour, you need to know how long something will take you to do. This helps you with several things. Pricing future projects more accurately regardless of how you charge for them. Invoicing any hourly work without having to guess how long you spent. And then seeing if you're becoming more efficient over time with similar work, which means you're increasing your profitability. If you need a time tracking app, check out Zapier's article on time tracking apps. Some of them are Harvest, Toggle, EverHour, etc. The link will be in the show notes. And as I mentioned in previous episodes, my team and I track all our time in Pancake, which is a project management system. So if you have a project management system, track your time in there. It's also a great idea to specify if you have any minimum rates to cover your time setting up the project, getting settled in, communicating with the client on updates, and then digging into the work. And maybe you apply your minimum rate when a project has been approved and the client wants additional changes, such as for making edits to a print file, and then having to redo your quality checks, preparing the file, and sending it to the printer again. Or maybe you have to get back into the custom code you put into a website and make some tweaks after the site is already launched. Like 90s supermodel Linda Evangelista once said, "I don't wake up for less than $10,000 a day." Now, I'm not suggesting that rate, but maybe your minimum rate for these sorts of small changes is $50, $100 or so. I also recommend including the rate for any additional designs and text revisions, meaning client changes, also known as author alterations or AAs, that are outside of the scope of work. So if you include 2 rounds of revisions and they go to 3 or 4, that's where they'd be out of scope. I typically price the designs as a flat rate and the AAs as hourly. Finally, I had notes that pricing is based on the assumption that the client will be providing finalized, edited, and proofread text unless I'm doing some of the proofreading. No rewrites allowed, like in that situation I described earlier. For deliverables, you should always list what those are going to be in your estimates or contracts. Nothing's worse than at the end of a project, a client has been expecting to get something else than what you're about to provide. Say that they thought you were going to give them a Word document of their letterhead instead of a PDF for the printer that you created from InDesign. Now you have to redo the work in another program. I've seen situations like this, usually with clients who hadn't worked with designers before, that have caused a lot of confusion that could have been eliminated by simply listing the deliverables. So it's about setting expectations. By the way, most of my agreements even specify deliverables as print quality PDFs, web quality PDFs, or, an actual website. Rarely has a client asked for or needed native files. Most cannot do anything with them anyways. They usually don't have the right software or know how to use it. But if they want them, I price them out separately. Then they can decide if they want them. These are your intellectual property, so you have the right to charge for them. Now, if you've agreed to provide native files, then when you package them up for the client, you have to be mindful of font and stock image licenses. You cannot simply provide them. You must check to see if those fonts or images can be given to the client freely. Not in terms of money, but freely in terms of rights. Or if the client needs to purchase their own license. And this applies to websites too, in terms of web fonts and stock images. Now, in terms of terms, there are several terms that I include in all of my contracts. The first is authority. You'd think this wouldn't be necessary, but a clause saying that the client contact is authorized on behalf of their company or organization to enter into the agreement with you and engage you for the services. Sometimes people think they have more authority than they actually have. Don't let that become your problem. The second is copyrights. If I were to work as a subcontractor, that is a work for hire situation. That means the client owns everything, the design, the files, etc. In most cases, though, I only want to grant reproduction rights to the client, unless they're looking to buy the rights, meaning the rights to the design and to the native files. For logo design, the client, of course, should be granted copyrights, but under 2 conditions. Upon payment in full, and then only to the final design, not any others that you created in the process, unless they want to pay additional for those 2. And I've actually had that happen, which was a nice bonus. The third is payment schedule and late fees. Getting money up front before starting work with a new client is non-negotiable for me. So you don't want to start work and then they disappear with or without your work. I mean, in the former case, they've run off with your ideas, and in the latter, you've only lost the time spent on that work. I specify how much they need to pay up front. Maybe it's 50% for small to medium-sized jobs and 30% for larger jobs. And then I include dates or milestones that I will invoice again. but I don't make those conditional on something being quote unquote approved, because the client could go round and round and approval never comes, and then neither does the payment. If the last payment is due before sending something to the printer or launching a website, then I would specify that too. If it's a new client, I recommend getting payment prior to job completion. And if a client needs to take, 10 or 30 days to pay, that's fine. But then it's like you just have to be sure to send the invoice to them, allowing plenty of time for that to be paid before the job completion. And then I always include when invoices are due, whether that's upon receipt, 10 days, 30 days, etc. And I address late fees. So the maximum amount that you can charge for late fees might be set by your state. For example, in Maryland, I can charge 1.5% monthly, which is 18% APR. So you may not be able to charge a willy-nilly fee of, say, $50. When it comes to expenses, unless they're being included in the pricing, I'll include a line somewhere that says the cost of a courier, fonts, printing, stock photos, hosting, plugins, etc., depending on what the type of work is, that those are not included. Before I started including this, some clients would assume that some of these costs were included. And then a cancellation clause. I'll include a clause that says if the job gets canceled, I still get paid for the work and any incurred expenses. Then a really important one is hold harmless. So to protect myself from being liable in situations such as, say, the client has ripped off their copy or photos from someone else, I'll include a clause that states that the client either has ownership of or has obtained proper licensing for all of their copy and any materials that they're providing, and will hold me harmless and indemnify me from any damages or liability, including reasonable attorney fees, as a result of a violation. And another very important one is limitation of liability. I include a limitation of liability clause, which pretty much says that if I screw up something, say I made an error and a print job had to be reprinted as a result, or I missed a deadline and ended up costing the client, or built an e-commerce website and it went down and the client lost sales, that the client can't come after me for more than what's stated in the clause. Well, here's hoping anyway. These clauses may or may not be enforceable in some jurisdictions, so check with a lawyer on that. There are examples of limitation of liability clauses online. In mine, I state that the liability shall not exceed half of the total fee for services rendered on the project. And I decided that because the client does have a responsibility to check the work. So as accurate as the work may be, and I even find incorrect errors they make, what if a phone number was accidentally typed in wrong? Or what if I were to accidentally type a stray letter or delete one somewhere? I mean, knock on wood, since that has yet to happen, but you never know. If you decide to include a limitation of liability clause, I recommend putting it in bold, underline, or uppercase, although that looks awful, but hey, it's just a contract. It's something that sets it apart from the rest of the text so that it gets attention. Another clause I include is promotional use. In some situations, you may or may not be allowed to show the work publicly, but if you are, then I recommend including a clause that says you're allowed to show the work on your website, in promotional materials, and in other areas online. In some cases, you may not be allowed to, as it might be like a confidential project or something. If you're acting as a subcontractor, then you may not be allowed to show it either, or you might be allowed to only if you specifically state you're part of the work and that it was done under the direction of, XYZ company. Working on a website has unique considerations, so I have clauses about that type of work. I have a clause that says the client is granting me access to their website with write permissions to all directories and files and access to their hosting provider. If it's a WordPress site, I also include the words as well as permission to install any necessary WordPress plugins for maintenance and security. I also have a clause that says if the client or one of their subcontractors goes in and updates the website and something goes wrong, it may result in additional fees and time to repair the web pages. That's another situation where, you could apply a minimum fee too. I include a clause that says I cannot guarantee a website's security, search engine rank, hosting, uptime, or that the site will be free from errors. No one can guarantee a site will never be hacked, and you cannot be responsible for the code of plugin developers or the accuracy of the content that the client adds to the website, if they're maintaining it. If I'm creating a site that's accessible to people with disabilities, that is WCAG Section 508 or ADA compliant, then I also cannot guarantee that when a client takes over the site, it will remain that way. So I include something about that as well. Another thing that I include is an expiration date. So I'll add a line somewhere, a bit prominently, but not in the fine print, that states how long the estimate or the pricing or the contract are good for. A shorter time frame of, say, 30 days can give a sense of urgency and provoke the client to accept it faster. And also, if you don't put an expiration date on it, they could come back months or a year later and expect to get the same price. It doesn't mean you have to accept that, of course. Obviously, your pricing can change at any time, but just saying. Sometimes I need to include a project schedule with actual dates for when I'll send the first proof, when the client should give feedback, when I'm going to send revised proofs, and they need to provide additional feedback. Final approval, preparing for the printer, and if it's a website, the launch date. But usually a schedule requires collaboration with the client to account for any holidays, time off, etc. So if you can't do that, then you can include a general timeline, such as, design will take 2 weeks or web development will take 6 weeks. This will help set expectations so that the client doesn't, 2 days later ask, oh, is it done yet? Depending on the client, say a corporate or government client, I might have to modify some of my terms. It might be something I don't object to, such as getting paid within 45 days instead of 30, or it might be something major, in which case I will consult with an attorney. In some cases, I've had to use their contract instead. Another case when I would have an attorney look at it. I've seen some contracts where the client wants me to take on liability on their behalf. That's never good, so I won't sign those unless they remove or modify that. I've also seen situations where a large corporate client wouldn't pay anything up front, but would after seeing a first draft. I think I could say I've seen it all when it comes to potential opportunities for misinterpretation or mismanaging expectations, too. So whenever something new has come up that I wanted to prevent or make sure someone works the way I want them to, I've added a clause to my contracts about it. What's most important in estimates and contracts is clarity on all of the considerations that I mentioned so that you protect yourself, not only from doing work without being paid, but legally as well. It's not necessary to use legalese to accomplish that either. You can write a contract yourself, adapting language from the AIGA standard form of agreement for design services, or the popular plain English contract killer, and then have an attorney review it or have an attorney well-versed in copyright and intellectual property write one for you. But I recommend doing one of those so you know that you're covered for the type of work that you do. Some other resources on contracts that you might be interested in are Better Relationships Through Better Contracts by attorney Matthew S. Johnston, several business and legal form books by Tad Crawford and Eva Doman-Bruck, and The Business Side of Creativity by Cameron S. Foote. As always, links will be in the show notes. And one last note, even if you have professional liability insurance, also known as E&O, which protects you from claims of negligent performance, that does not take the place of a good, solid contract. And I can't reiterate enough. For all new clients, get a signed contract and money up front. If you found this episode helpful, please subscribe and leave a review. Go to creative-boost.com where you can sign up to get notified of new episodes and posts, share on social media, or leave a comment. Thanks so much for listening.